Numbers to come in. Good morning, all.
Morning.
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 Carol, the last time I think I saw you was at an Indians World Series game.
Yeah, it was an unfortunate game, wasn't it?
It was, but that speaks to how long it's been.
I know.
Good to see you.
Nice to see you. And Judge, we went to law school together.
We did.
We did. but I'm glad you responded that way.
Let me see what you. Oh, okay. Yes, I did. Was your name Carol O'Brien then?
It was Carol Hamilton.
There you see. How would I know, right? I wasn't invited.
Yeah, well.
Congratulations.
Okay.
Congratulations on multiple things.
Well, yeah, we don't want to talk about that first one. That's been over for a while.
All right. Well, welcome, Carol.
Thank you. Thank you.
You are Doug's immediate supervisor?
I am Doug's immediate supervisor, but I just want to let you all know that he is one of the smartest people I know, and he runs rings around me on a regular basis. So just saying.
All right. So I presume he's kept you apprised of our developments, and so although you're pitch hitting for him, to use Judge Savaggio's baseball analogy, you are well versed in where we are in this. So
I hope so. Yeah, I've gone through the rules, the
Yeah,
33-1 pretty extensively, a little bit on 35, and then
excuse me,
went through the minutes also. So thank you.
Mr. Gotzi, thank you for joining us. I am looking for one thing real quick, and then Brian and or Catherine, can you tell us how we're doing on attendance?
I believe Judge Salvaggio hasn't logged on yet.
Yes.
Oh, sorry. There you are. I was looking in the sidebar over here. And then, let's see. Judge Cost told us he wasn't going to be able to make it, right?
Right, he's got an I-Court meeting.
And so did Senator Gavarone.
Yes.
Judge McIntosh not on here.
So we have a good assembly other than that. So let's get started, everyone. We have a lot to vet and review. Hopefully we can get through it all. So we'll call the March 19th meeting to order. First order of business would be the approval of the February 12th minute meetings. Hopefully you've all had a chance to review those documents, and any effort to modify, change, or is there a motion to approve? There's nothing. Judge Savaggio, you're moving to approve? Thank you. Is there a second? Judge Berger, second. Okay, all in favor signify by your hand being raised. And thumb or hand. Any objection? Seeing none, it's approved. All right. The agenda item, you'll see that I've added a new section in this first bullet point for our agenda, which I've characterized as news related to wrongful conviction. And you'll see there's three specific items that hopefully either you have already reviewed or watched and or have it scheduled to do, maybe even this weekend, right? With a nice big bowl of popcorn, watching at least the video. The reason I'm doing this, I have done this and will continue to do this now, is as this task force progresses in its work and as time passes, the amount of stories that I'm becoming privy to, that people are sending me, that I just see, that I think are pertinent to our work and our effort, and help give us a better perspective of where we are elsewhere, or what other communities, both in Ohio and principally outside Ohio, are doing as it relates to this issue of wrongful conviction and how communities are trying to manage or handle them. I think it's important. It gives us a good perspective. You know my efforts in trying to bring in resources from outside Ohio to give us their thoughts, because other communities, I think, are much further along than we are. So why not be exposed to all of that, which is why I've done and have added this, and we'll probably each month, each time we meet, we'll have additional articles. So to that end, if there are specific articles that each of you become aware of, I have no objection forwarding them to me. The more informed we are, the more informed, and I think more appropriate the ultimate recommendations we make out of this task force shall be. And I would welcome all of that. I, in particular, would encourage you to watch the video of the Conviction Integrity Unit's perspectives on best practices. That was a lunch hour seminar that was sponsored by the John Jay Criminal Justice School. And it was very informative. It gave the perspective. I think there were all it was three CIU prosecutors and then Brian Schmenk. And it's really interesting perspective about if you are going to create a CIU, what are the practices and what are the pitfalls and the obstacles as it relates to the generation of that. That'll be well worth your time and attention as we move forward in the discussion, especially after we get through the structural issues that we dealt with last month and this month, and then the training and ethical issues that I hope that we will be able to address in next month's meeting. Okay, so that's one preliminary matter. The other preliminary matter happens, and hopefully his screenshot is next to me and your respective screens. But that is, I did want, and I asked Justin Cadella to appear today. As all of you know, Justin has, for some odd and strange reason, thought that becoming a court administrator of Delaware Municipal Court is better than being the staff person assigned to this Conviction Integrity Task Force. And as a consequence of that errant decision on his part, no, he's left the court's employ. I wish him all the luck. He's done, as you all know, as you've interacted with him, he really has done a wealth of work between him and Catherine. And we will miss him, but we are trying to not miss a beat. And I just wanted to publicly commend him for all of his efforts and fine work in where we have progressed in this task force. We couldn't have accomplished this without you, Justin. And I want to publicly thank you for your time and effort. And I appreciate you coming in today. He said he might come by and watch periodically, since, as you all know, these are publicly available Zoom meetings. So Justin, I want to thank you. And in conjunction with thanking you for your attendance and participation and all your effort, also, hopefully all of you can see Brian Schmenk, who is now the new Justin, but he really is the real Brian. And he's the new staff person replacing Justin, staff attorney in the Supreme Court, and is filling those big shoes that Justin has created for us all. Next to me is, of course, Catherine Patterson, who continues to be a great asset in all the logistical issues that we find ourselves needing to vet as we move forward on this task force. So welcome, Brian. Wanted to introduce Brian to everyone and thank Justin and introduce Catherine, who I probably have not done. I don't think I've done that before. Have I, Catherine? Maybe not.
Maybe not formally. I gave a
staff
little walkthrough on the Google Doc in a previous meeting. So
there you go. Oh, that's right. That's true. So anyway, so that's the staff that we have here in terms of managing this task force. So thanks, Justin. Anything you want to say before you, because I know you're going to watch a little bit and then head out.
Yeah, I mean, thank you, Judge. Thank you, everyone. It was great working with all of you. I'm sorry I can't help continue to finish the work of the task force, but I'll be monitoring and answering any questions Brian may have, and I look forward to seeing the final work of the task force. It's been an honor.
Thank you very much, Justin. Take care.
Thank you.
Okay, so one other item, and I see, did I see Joanna? There you are, Joanna Sanchez. I was reading about you this morning because you apparently have a day job and have been spending a lot of time up in Cleveland.
I have.
So And the reality is, I've just became aware of a decision rendered by the 8th District Appellate Courts, State of Ohio versus Michael Sutton et al. And Joanna, were you lead counsel or co-counsel? I couldn't tell. You're listed as counsel of record in this case. Was Mark lead counsel?
Yes, so Rachel Troutman and I with the Public Defender's Office represent Kenny Phillips, and then Donald Castor with the Ohio Innocence Project represents his co-defendant, Michael Sutton.
So it's a significant decision. It's about 54 pages. It's 157 paragraphs, unanimous decision reversing a trial court's denial of a motion for a new trial that I think is worth reading and exploring because it helps address and focus some of the issues, actually a lot of the issues that we are confronting with. What are the guardrails that should be in the system that would prevent a wrongful conviction to begin with? And really what happens in our focus, which is what happens when those guardrails aren't there, and how do we go back and what protocols and processes should be in place. And that's really what we're attempting to do in reviewing what our current practices are with respect to post-conviction / wrongful conviction and vetting other opportunities. So I just got the decision. I forwarded it to you, Brian, so you can, and when you have a chance, I think we should forward it to all of our task force members. It's well worth the read. There is actually a pretty lengthy news article in one of the Cleveland periodicals, I believe the Plain Dealer. Mr. Young, you keep shaking your head like you're aware of this. That's because your office is aware of this, right?
Oh, we're very proud of Joanna. Yeah, no, we're this was huge news yesterday throughout the entire office. And had you not mentioned it, I was going to.
Well, I think it's salient to our
praises and Rachel Troutman's praises. They've been working on this case for years. I want to say we started investigating in 2014, maybe even sooner. It's been going a long time, and she has done just an excellent job on this case. So thank you for mentioning it. But yes, we're very excited about it. And we're incredibly proud of their work.
It certainly is a nice lead. If it had been issued sooner that we could have incorporated it, I would obviously have shared it. But I literally just got it. So and was trying to peruse it this morning before coming online with this task force meeting. So I haven't gotten through the whole thing, but it's just a significant decision that we need to parse and understand, because I think it addresses much of what we are about to talk about. So having said that, any other comments or discussion points before we get into addressing 33.1 by anyone? Mark, there you are. Do you want to say anything with respect to your office's involvement or no? We can't hear you.
You're muted.
He's going to sign off and sign back in.
Did you hear that, Mark? You should sign off and then sign back in, and we'll get to.
That's what he's going to do.
We'll come back.
Just posted it in the chat.
Oh, he posted in the chat. Thanks. Yeah. Oh yeah, the decision he's. Interesting comment, Mr. Martin. You referring to Rutherford B. Hayes?
Of course, Your Honor.
There's a plaque in, I don't know if you know, have you ever seen the plaque in Delaware? The Rutherford B. Hayes plaque? You have, right? Isn't it right next to a BP gas station?
Well, that's because that's where his former home used to be. And then after they realized they had destroyed history, they figured it might be a good idea to do something. We also now have a statue of him in the at the square at one of the main intersections.
There you go.
So
All right.
much
Can you guys
much
hear me
better.
now? Can you guys hear me?
We can, Mark.
Beautiful. I was just going to say we piggybacked on the great work of Joanne and Rachel.
There you go. All right.
What we call a Me Too brief.
Familiar with that. All right. So let's get into the meat of the matter, 33.1. We sent out so what we attempted to do was create a standalone rule based on our discussion, and that was vetted. Well, we sent it out to its proponents with an effort to vet that document and send any modifications to it or not. Mr. Young, if you want to comment relative to your group's effort.
Yeah, thank you, Your Honor. I spoke to you a few days ago about our lack of progress. During the last meeting, we talked about the option of creating a completely separate innocence rule. And we convened and talked about what that should look like. And honestly, fairly quickly found ourselves facing what we thought were both insurmountable problems, both in terms of defining that. I mean, earlier in discussions, one of the things that came up was, well, we don't want to include like credibility issues, but I would invite you to read that decision. While it's a Brady case, it's a credibility issue. You have two completely diametrically opposed versions of what happened in the Sutton case. And it points to exactly why it is so hard to define what would fit and what wouldn't fit in an innocence spectrum. And it is a spectrum. That's the problem. The other issue that then comes up, and John Martin pointed it out, and we just continued to fight with it, was the ethical issue of choosing which standard you would file under, and what does that say about clients that you don't file under the innocence side, but you're still claiming that obviously that there's some due process problem and that their trial should happen again. Because of those and that inability to define that spectrum in any meaningful way that you could find a jumping off point, we want to apologize for any waste of time, although I don't think there was much since we were in the midst of editing the rule as we were working through it, and we're recommending that we go back to and pick up right where we were on that editing. I would invite Mark or John or Joanne to comment if they want to flush out our conversations at all about why we couldn't move forward and figure out that separation piece.
Yeah, I mean, I would just echo it would be unworkable for the reasons that Tim stated. In addition, it fails to understand sort of how these cases work. It's almost impossible for somebody to affirmatively prove innocence. And you look at the cases, even like the decision from yesterday, and many of them, there's, the cases, the state's evidence is completely undermined in every way, and there's evidence pointing to innocence. But unless somebody has a passport proving they were out of the country, it's impossible to prove innocence. And particularly, for people like us in a professional class where we've got secretaries and people keeping our calendars, it's one thing, but most of the people that get caught up in this are not individuals who have somebody keeping their calendars and can demonstrate where they were 2 years ago on X date. And so it's, many of these crimes, it would be hard for even me to prove that I didn't commit it. And it's particularly harder for somebody who doesn't have a secretary and doesn't have a calendar and doesn't have, all these things that are documenting where they are at any given time. So for many different reasons, I mean, if we passed or we recommended something like this 33.1, it would set the movement back. It would make it much more difficult, I believe. And so we need to be, I think I agree with Tim, go back to the draft that we were working on before and work on perfecting that along the lines we had suggested.
Judge Savaggio?
Mark, I think you make a good point when you talk about, for some of us on this panel, we don't really see the inner workings of how these cases develop. But one of the things that Tim said that kind of piqued my interest is, we tell the jury every day in our jury instructions that they are the sole judges of credibility and that they can believe all, part, or none of a witness's testimony. And I haven't read the Sutton decision, so I'm not really sure of the dynamics of that case, but how do we reconcile the fact that we tell the jury that they're to judge credibility against somebody who claims actual innocence because the jury should not have believed that witness, they should have believed me?
Yeah, Mark?
Well, I mean, I wouldn't bring a case in post-conviction saying the jury believed the wrong party. You know, if two witnesses gave diametrically opposing testimony and the jury agreed with this witness, it's not a grounds to come back to court and say they should have believed this witness. But the reason why credibility, I think, is important in post-conviction, where it would rise in one of our cases, is let's say the conviction hinges primarily on the testimony of one person. And that witness was incentivized, but got on the stand and said, I've been given no deal, you know, et cetera, et cetera, et cetera. And then it later came out through a Brady violation that they had just been arrested for murder and been given immunity, you know, some egregious situation. And on our position would be, because the jury needs to assess credibility, that person deserves a new trial, because a new jury needs to hear this, where all the cards are on the table. Or like in the Sutton case last night, two officers testified to a certain version of facts. And that was basically the only evidence in the case. And it turns out that there were two other officers at the scene who completely contradicted and actually agreed with the defendant's stories. And their reports were sort of brushed under the rug, and didn't see the light of day. And so you can call that, is it an innocence case? Well, I think they're innocent. And I think the fact that these new officers corroborated the story of the defendant, when you step back and look at it, you go, I don't think these guys did this. But in many ways, that's a credibility case. And, you know, in the Sutton case, the prosecutor stood up in closing arguments and said, these are two highly decorated officers. You should believe them, while they were suppressing the statements of two officers who were saying the exact opposite. So is that innocence? Is that credibility? But they deserve a new trial, so that all the cards are on the table.
Right. Shouldn't the standard be whether the new evidence totally undermines the theory of guilt that was used to convict them in the first place? It doesn't matter at that point whether the trial court judge believes the new evidence or not. If it undermines the theory of guilt, there needs to be a hearing. This case emphasizes the need for trial court judges to hold hearings to determine whether this new evidence meets that type of standard. And trial court judges have been ruling on motions, and it happened in this case. You know, the state came back and said in a brief in opposition, you can't believe this officer because he was convicted of something. He's mad at our office. Well, maybe that's true, but how do you determine that without having a hearing? And I think that needs to be built into any improvements, that incentive to hold a hearing.
I think it's important to frame it a little bit, Judge Savaggio. The Sutton case is not a reversal of the conviction because they have been determined to be innocent. Rather, the trial court found, the appellate court found error, as I understand it, in the trial court's failure to hold the appropriate hearing. And because in the trial court, in the original conviction, the failure to disclose what they constitute as Brady information or Brady material, because of 4 police officers that were eyewitnesses to the events that gave rise to the offenses, right? Only 2 testified. The other 2 were told not to testify, and their testimonies happened to not reconcile with the other 2. Well, that variance of testimony was never disclosed at the original trial level, which ultimately led, I think, to the appellate court's ultimate decision, which says, you get a new trial. That's all that really happened. We know that's significant, right? But this isn't the kind of innocent reversal where they have been determined to be innocent. All they're getting is, they're getting the trial that they should have gotten originally. And I think the issue that we need to look at is we talk about wrongful convictions where somebody who declares their innocence and wants to understand the mechanism or the framework by which they can establish that innocence in some post-conviction proceeding is one category. And I think all Mr. Young is trying to suggest is there is this other category which says, would you describe this case as a wrongful conviction case? I think we would, right? Given the Brady violations, but it doesn't result in the determination presently, at least, as to their innocence, merely their ability to have the trial which they believe they should have had initially. And is that something that we should be addressing within the context of our task force? Okay, John, then Carol, and Pierre, you wanted, yeah, okay, John, Carol, Pierre.
Thank you, Your Honor. 3 quick points. Judge Salvaggio's concern about the primary role of the jury as a fact finder is a good one. And what I would say, though, is this: when we get into these newly discovered evidence situations, it is not that we are expressing a lack of confidence in those 12 tried and true. We are recognizing that they were hamstrung, that they were victimized by virtue of the fact that they did not get all of the necessary evidence. And so therefore, they were required to make a decision based on a lack of information. And it's for that reason that I don't think we're in any way questioning their credibility. We are rather recognizing that they were impeded in that primary role that you so correctly described. Second point, take that and combine it with what Mark talked about before about this notion of being able to prove innocence. We have an eyewitness who says John Martin strangled that poor woman to death. Okay, and we've got other people who are saying, no, it wasn't John, et cetera, et cetera, et cetera. And now DNA evidence comes out, but it's somebody else's DNA around the throat of the poor victim. Does that mean I didn't do it? Not necessarily. That DNA could have been a secondary transfer because I had touched that person and now put their DNA there, or that victim had some other contact. And that's the reason why, to emphasize Mark's point before, that you can't have to an absolute metaphysical certainty, to use the old John McLaughlin term, a situation where you have absolute innocence necessarily. Third point, even within the jury framework, Ohio law has recognized that there is a place to second guess a jury, even on the basis of what they just heard without more. And that's the fact that we have the Court of Appeals has the jurisdiction to be able to reverse a conviction for manifest weight. So we do trust a jury, but at the same time, we still have a safety net. Those 3 points is all I had to make. Thank you.
Thank you, John. Carol, welcome.
Thank you. Just a couple things. Yeah, actually, the definition of innocence is pretty easy, isn't it? It's the person did not, in fact, commit the crime of which they're accused. So I don't think that's a hard definition to get to. And in terms of new evidence, I think what we're talking about in Sutton was new evidence to the defense. They didn't have it. Mm-hmm. So those are not insurmountable hurdles in terms of coming up with this. And it's my understanding, and guys, I totally admit, first time here, you guys have been working on this a while. This is specifically geared towards actual innocence because we have our wrongful conviction statute and rules already, right? Tim, Mark, I know we were just looking at one for you with DRC and getting that DNA sample. So, we have two separate actions we're looking at here. One is a wrongful conviction, which can be a Brady violation. It can lead to wrongful imprisonment actions. Believe me, I see those all the time. They're not fun. But this is different. It's my understanding, and if I am wrong, please shut me down. This whole task force is set up to deal with actual innocence, not just someone claiming that that person lied and the jury believed that person and not me or not my witnesses. I can prove I am actually innocent, and here's how I'm going to do it. And I get the fact that most people don't have calendars. Heck, I probably couldn't look back in my calendar and see where I was. But DNA can sometimes definitively say, yeah, it was someone else's semen in that woman. So I wasn't the one who raped her. And at the same time, it can also put someone there. So I think I want to make sure we're talking about actual innocence. That's what the goal of this is, not a wrongful conviction, because, you know, we have habeas case, we have habeas procedures, we have the 2953-21 procedure in state court. We have the wrongful conviction statute, which is what I'm assuming you guys used on Mr. Sutton and the other case that came out. So we have that. This is for those folks who are actually innocent, right?
Well, let me clarify that. While the emphasis and the majority of work, both based on what our charge was from the Supreme Court, as well as what we have collectively in our initial meeting recognized, is addressing actual claims of innocence. It's clear as well, and I've commented on this a number of times, Carol, that we are charged with looking at post-conviction practice in Ohio. Because, and I think this is prudent to do this, as you look at and vet the wrongful conviction process, we will be, and later this morning, we're going to look at 2953-21, post-conviction relief petitions. To the extent that we find or we believe that there could be improvements in post-conviction practice, especially as it relates to these wrongful convictions mean innocent convictions, all right? Or innocent petitions. But if there's something that we believe is worth recommending, a modification, clarification, improvement that addresses current post-conviction practice, it's still within the purview of this task force. We haven't identified that, okay, because our focus truly is on the innocent petition. But it's not to the exclusion of saying that's not us. We're not going to do that, all right? Because I think we would be, biting our nose off in spite of our face if we only looked at it and said, I don't care about post-conviction practice because it doesn't pertain to the innocent petition. Justice Donnelly, I see you.
Yeah, I appreciate Carol's point here. I mean, the conversation started off with, if innocence is really hard to define. No, it's really not. They didn't do it. Sutton and Phillips maintain they didn't do it. And that's what we got to keep our focus on. That's what we're trying to give. We're trying to improve the guardrails when the guardrails on the front end fail, because the guardrails on the back end aren't working for the people that maintain, I didn't do it. You got the wrong guy or woman. And I think we can define actual innocence. They didn't do it. I'd like to hear the response.
I may, Justice and Carol, it's not the question of whether our clients are saying they didn't do it. It's whether we all agree on the proof, what that means when we get to that point. We are standing in a case today that we believe, and our clients are saying they're actually innocent. On the other side, we have prosecutors who are trying to make sure they stay in jail for committing these heinous crimes. Today, in that case, are they actually innocent? Yeah, we're claiming that, but does this Brady violation, because that's how it's going to come up through a new trial motion, make that claim? And what's that spectrum that we're saying, do you have to make that claim in every case? It's the question isn't, we can all agree factual innocence is factual innocence. They didn't do it. I don't have any disagreement. I don't think anybody on this panel has a disagreement with that's the definition. It's the question of what proof gets to that definition. And we disagree about that all the time. That's the functional issue of trying to define the rules that allow the level of evidence to get to that higher review standard or less burdensome due process restrictions, whatever those are, or however you want to define them, to make sure we are hearing those claims when we should. But the problem is defining, what does that mean? I think it's not the question of defining actual innocence at the end of the case. The question is, what evidence gets us to that level of review?
Pierre?
Yeah, so I want to go back to the structure question of whether we propose breaking out this into Rule 33.1 or try to integrate it in Rule 33, because I think the reason we went down this path in the first place was recognizing how difficult and challenging it would be to place a carve out under existing Rule 33 without suddenly opening up the floodgates and creating the concern in inevitable backlash that we're going to allow, new trial motions at a drop of a hat. And so the idea was, let's move the actual innocence new trial motions to Rule 33.1, and we can define how that looks like, so that it doesn't create the concern that we're going to broaden the existing Rule 33 beyond what would be palatable. So I understand, I hear the concerns. I think that's why we went down that path in the first place. And the question is, if we go back to where we started, is there a way to do that that addresses the concerns that we had at the outset, and that would be better than what is proposed in the Rule 33.1? So I don't want to lose sight of that concern that we had at the beginning and why we went down this road.
Well, and then as a corollary to that, is there potential modifications or other clarifications that could be implemented either in 33 or 33.1?
Well, and also to respond,
that would help address the concerns, because I think one of the biggest concerns that both Mark and Tim have raised is the notion that the position you're putting that lawyer in to have to make the election, is this innocence or is this due process?
But I think that, I don't see why a lawyer, if they were in doubt, would not move under Rule 33 and, Rule 33.1. And obviously to take advantage of both potential options, obviously you would, make those arguments, but it's not like you would have to forego one.
All right. Thank you. Anyone else? Nick?
I think John and Justice Donnelly maybe crystallized for me at least a pathway to resolving this issue, which is, what is it about the prosecution of the case that undermines the integrity of the conviction? And if you look at concentrating on the word undermined, then we don't get into some of the concerns that I think I initially had, which is focusing on the credibility of the witnesses and focusing on maybe some of the extraneous stuff. And to the extent that we can maybe focus our effort on whether the process itself was undermined, then it seems to me that issues that may have crept up in Sutton, issues that Mark talked about, might kind of take care of themselves.
And doesn't then that support the proposition of carving out the innocent process under 32.1, as opposed to trying to, create a subcategory in 33, right? Who else that has not opined yet, wants to comment relative to, that's one of my favorite words, as it relates to this concept? Because we put Joanna.
I just wanted to address Judge Bergeron's concerns about opening the floodgates. I think if we keep this all housed in one rule and address some of the procedural mechanisms that prevent people from having their cases heard, I don't think that'll open the floodgates, because I don't think there's a lot of people right now who would file but for the difficult procedural barriers. I don't think that's stopping them at this point. And I don't think that would result in a lot more new trial motions being granted, because we still have the backstop of Brady or Petro, the actual standard that gets you the new trial on the merits. I think what we're looking for is a shift in the analysis. And so that judges are spending more time and more of their resources looking at the merits and actually getting to the real question we care about is, was there a due process violation? Did this person commit this crime? And spending less time on some of those procedural issues, like did they file in time? By way of example, I litigated a case for 6 years on the question of whether, after my client found the evidence, did you file within a reasonable time? So 6 years, went back and forth between the Court of Appeals and the trial court 3 times, had an evidentiary hearing, went up to the Court of Appeals, Supreme Court, and ultimately we lost. And in all that time, nobody ever just considered the merits. Did this guy do it? And I think what we're looking for are some small but important changes that just shift the focus. And I don't think that'll open the floodgates. I think it's just a better use of judicial resources.
So if you're saying it's simpler to modify existing 33 than trying to carve out an entire new process under 33.1.
Yes. And I think, to Mark's point and Tim's point, I agree, in the real world, innocence means did you do it or not? But in the world of wrongful convictions and innocence organizations, that's not what it always looks like. I mean, of course, we say our clients didn't do it and they didn't, but the way you get to that, the way you get to relief is through Brady. When you look at the National Registry, 44% of those have Brady violations. You're looking at recanted testimony, changes in forensic science. And so those are innocent people, but most cases don't end in a declaration, this person 100% didn't do it. In terms of the criminal case, it might when you get to compensation. So we need to look at what's an actual proxy for innocence. And I think a carve out will make a sort of super standard of innocence that it's difficult to meet. And then we'll force other people to litigate cases in a way where they're saying, I'm not innocent, so I'm under, the regular Rule 33. And I think it creates difficult standards for both sets of litigants, and has the opposite of the effect from what we intend.
All right. Thank you, Joanna. Anyone else wish to comment?
Yeah, I'll just jump on what Joanna said. It's, when you look back at when this started, what the Ohio Innocence Project submitted was very, very minor changes to Rule 33. And Rule 33 now is hard to meet. You have to show that there's a substantial probability that the outcome would be different, that the person would have been acquitted. It's not easy. And what Joanna said just perfectly summarizes the problem is that the litigation, the way the procedural rules are set up, or the court created rules, the courts are spending all their time on, like, did the counsel bring it diligently, and these sort of like questions that are side issues. And in her case, they litigated that for 6 years and didn't even get to the merits. Even when we have strong cases, it's hard to get judges to grant these. I mean, look at the case that they won on the Court of Appeals yesterday. It was dismissed by the trial judge. It took years of litigation to finally get a recognition that it was a Brady violation. And so, I'm looking at the strong cases we file and how quickly the courts get rid of them. I'm thinking, how can this be? And when there's actual litigation that's clogging up the courts, it's over all these procedural bars. It's very easy to spot a weak case if there's all these frivolous cases being filed that don't have affidavits attached to them. I mean, we're not filing those, but even when we do file them, we're getting them dismissed very quickly on procedural grounds. So I can't imagine that if there's all these frivolous claims where people are just making these allegations, they don't even have evidence to back it up, or experts or affidavits and things like that, the court's not going to spend more than a few minutes getting rid of that. But the point is that, if you look at our original suggestions, they're just very modest procedural things that shift the focus from wasting all this time on procedural stuff to just get to the merits quickly. and determine that issue of whether it's a substantial probability that the outcome would be different. And if it's a BS case, then it's going to be very easy to determine that. And so I think that's all that's needed, which is why when this started, our requests were extremely modest.
So where does that leave us then as a task force? Because we have a framework for 33.1, if it's the consensus of the task force not to pursue that at this juncture, but rather to revisit modifications to the existing 33, let's deal with that. I think we just need to make a decision and move on.
I guess, can I just add one? I don't think it matters whether we do it in a separate rule or within 33. I think we've all kind of articulated really valid concerns, but reiterating what Judge Salvaggio said, it's about, was the theory of guilt presented in the original trial? Every case is simply that. It's the state presenting a theory of guilt. Knowing that, does the new evidence undermine what was presented to the jury? And how do we get to judges to focus on that rather than, when did you find this out, or timeliness and all the rules that promote finality over the merits as they exist right now.
And do you then envision modification of 33 that gives discretion still to that trial judge to say you have to meet a certain threshold before you're entitled to a hearing on that issue as defined by you, or not? In which case then, as we heard before, if you assert it in the right way, if you're automatically entitled to a hearing, does that open up the floodgates where the trial courts are hearing?
Well, the floodgates is a myth. And I think Jim Petro articulated in his book, the belief out there that everybody that gets convicted maintains that they're innocent. That's not true. In 14 years on the trial bench, I only had one person who, after a plea, claimed that they were innocent. And I had a hearing on that matter. It took 20 minutes. And it turns out the integrity of that conviction was upheld because the prosecutor was able to present evidence that they would have presented if they went to trial. And that's all it took. And that hearing taught me a lesson. It's the myth that everybody the floodgates are going to open is just not true in my experience.
Yeah. All right.
Yeah. So if I could just follow up with what Mark and Tim and Joanna said, to make sure I understand, because I think the purpose of the Rule 33.1 was to eliminate those unnecessary procedural barriers for innocence claims, but also provide additional protections for those claiming actual innocence that at least as I understand it, would not be in the existing Rule 33. So I guess I just want to make sure I understand why you all think that it would be disadvantageous from your perspective to amend the existing Rule 33. I'm sorry, to go with Rule 33.1 versus adding something to Rule 33.
Mark?
Well, okay, so for when we're looking at a case, are not going to bring the case unless we believe the person's innocent. Okay. So in the last 6 months, we had a case that presented an egregious Brady violation. No question in my mind that we could have won that case. Did not bring the case for reasons I'm not going to get into, having to do with privilege. So we are making a determination that we think the person's innocent, and we will drop it if at any point during the litigation it becomes clear to us that they're not. But proving that is virtually impossible in these cases. In fact, so we're bringing Brady violations, we're bringing that, they were convicted on a combination of science, which is now outdated. And when you look at the updates, you can see that what was used against them was not reliable. Plus there's Brady violations, plus there's a recanting witness. It's a full in-depth investigation that by the time you get done with it, you go, the stuff that convicted them is no longer reliable. And in fact, when you step back and look at it, you sort of go, I think this person's innocent. But can they, with the burden of proof, affirmatively prove their innocence? That's going to be extremely difficult. And I'll tell you why I believe it's difficult, because even when we have the really solid procedural grounds, we have a hard time getting the courts, in my opinion, to look at them objectively. And if we're already getting a hard time having them even agree that an egregious Brady violation is even a Brady violation, in the compensation statute, they originally had to prove by a preponderance that they're innocent. And it's so hard to get courts to agree with that, that the legislature amended it and allowed compensation for Brady violations because it's a good proxy. You can't, when to win a Brady case, you've got to show that what was withheld undermines the case to the point where you would have been acquitted. And so, they're not exactly the same as innocence, but it's the only mechanism that you can actually, you talk to anybody in this world who's doing this work, it's really hard to get a court to say, I agree this person's innocent, unless the prosecutors agree, and they almost never agree. It's a rare case where they do. And so, I'm speaking just off the cuff here, but like, I don't have a problem if I have to say to a court, we're bringing this case on procedural grounds because it's Brady and it's shifting science and it's a hodgepodge of different things that we're bringing to your door. And I, as an officer of the court, believe this person's innocent. I wouldn't be bringing it unless I were. I don't have a problem saying that because that's the only kind of case I'm going to bring. But if you put a barrier that we've got to get a court to agree that they're innocent, it rarely happens. It rarely happens that you're going to get a court to do that. And again, just go through it. This would take, I wrote a book about it, but I can sit and go case after case where if you talk to a reporter, and we'd have reporters covering the case, they go, this guy's clearly innocent. But you can't get people who've been entrenched in the system that long to look at it with that same objective view and who are deeply invested in that case. And it's understandable. That's human nature. And so I don't have, I do think it's about innocence. But if we make the standard that somebody has to prove they're innocent within the existing system, it's going to be extremely difficult. We're going to make it harder.
I don't think that's what we're talking about. We're not talking about they have to prove their innocence. All they have to do is establish that the theory of guilt was used to convict them in the first place. The theory of guilt that convinced 12 people that they were in truth guilty beyond a reasonable doubt has been undermined. And
that's what the existing rule does. You have to show that the new evidence would have changed the outcome of the trial.
Right. Well, why is it not working? It's not working because you have to fight tooth and nail over whether you get to even have a hearing. And
right, that's what I'm saying. We're on the same page. We need to change the procedural stuff.
Right. But getting to your point, you won't take a case unless you believe they're innocent. There might be cases where you decided that they were guilty and they were truly innocent. It shouldn't be on the belief of the advocate or the judge. It should be give them their day in court on the back end so that the merit of their claim, that should control. Their claim, the prisoner, I'm innocent. I want to show this tribunal evidence that undermines the theory of guilt that was used to convict me. And it can't be trusted. I need a new trial. That's it. So why not have to highlight what we're trying to do? The whole objective of this task force is to help the actual innocence, even though there's a lot of unfair convictions out there that affect the guilty that need to be addressed as well. But we want to help the actual innocent who maintain it, whether we believe they're innocent or not, or whether the Innocence Project believes they're innocent or not.
All right, Carol, then Joanna, then Tim.
So we have already, and Mark, I understand where you're coming from when you're saying we are the Innocence Project, we're going to represent those people who are innocent. So I get that. but there's a whole history and number of statutes and laws that allow people multiple opportunities to question the integrity of their conviction. And Joanna, you just went through it for 6 years on your case. Could it have been lesser time? Maybe, but we have that part. And I think what I thought this is getting that extra at any time. If you can say, you know what, there's evidence out there that shows I'm innocent and this is what it is. Newly discovered evidence, they didn't give it to me, the prosecutor didn't give it to me. Yes, that happens. Hate to admit it, but yes, it happens. But so I think that's what Justice Donnelly is saying. I think that's what Judge, I'm going to Ms. Bergeron is saying, that this isn't in place of what you're already doing. It's in addition to what you're already doing. And one of the things that we probably need to discuss in there is there's nowhere for a prosecutor to file one of these actual innocence claims. And I know there have been prosecutors who've said, you know what, we did a review and this conviction was wrong. So I think it needs a lot of work, frankly, as someone who practices in this a lot. Tim, Mark, Joanna, I'm missing someone in here. You guys do this all the time.
Mm-hmm.
You have people out there who don't do this all the time. Breaking it out would probably make it easier for them to decide which way to go than to keep it into one and have 9 million subsections.
So I'm sorry, Joanna and then Tim.
Yeah, sorry.
No, I just wanted you two, I'm just mindful of the time and I want to, it's great discussion, but I want to be able to frame it where we're going. So we have to move this along. So Joanna,
Sure.
how's that for the floor is yours.
I'll be quick. I agree with Justice Donnelly. I just think the carve out's not necessary because under 33A6, that already defines your body of cases where people are alleging innocence. They're saying, I have new evidence that creates a strong probability of a different result. I have a Brady violation that undermines confidence in the outcome or creates a strong probability of a different result, or reasonable probability of a different result. So that is your body of innocence cases. And so what we're saying is that all of those cases deserve these reduced procedural barriers so that they can actually be heard on the merits because they're all potentially innocence cases. And so I think if we create an artificial line there, it creates a situation where some of these people who are potentially innocent cases aren't going to be heard and are going to have to face these higher procedural barriers, but they're all innocence cases that at least need to be considered and on the merits and ferreted out.
Thank you, Joanne. Tim, anything more? You had your hand up.
Just very briefly, and I think it's been emphasized, so I'll be as brief as I can. It's not about the innocence at the end. Like I said, it's as Mark described, there's this whole different combination of evidence that's going to come together in a case, and it's rarely one thing. It's multiple things. The problem is, when do we get advantage of that other rule? And that's the problem we keep trying to define and why we're saying it needs to be in the same rule is at what level on this spectrum do we jump to this new rule? When we have DNA, when we have recantation and Brady, when we have Brady and misidentification, what combination, and we can't figure that out. That's the piece. And so that's why we're saying the spectrum. You start with cases that we're not going to have agreement on innocence, but at the end of the case, should we have gotten the hearing, we can undermine the theory of the case and the verdict. We may not ever have agreement, though, on whether the person was factually innocent. We regularly disagree in these cases at the end. The question is on that spectrum, if we divide two rules, where's the trigger? And that's, I think, an impossibility to define, which is why you're trying to say you should have this reduced barrier on all of these cases that are asking for a new trial. But when you're alleging, we say that we have evidence and we've provided affidavits or new science supported by experts that this now undermines confidence in that jury verdict and would have a strong likelihood of a different outcome or a probability of a different outcome, depending on whether it's Brady or how it's coming through the courts. Sorry, that was longer than I meant to go, and I'll shut up. I apologize, Judge.
No need to apologize. I love the discussion. But the reality is we are now faced with the prospect that some are clearly suggesting that the work done in carving out a 33.1 may not be necessary or is untenable and can't be defined in such a way that it practically has application, and we it's being recommended better off if we attempt to modify existing 33. As I look at it as the chair and trying to move us forward, I think I don't hear a consensus of the task force in that new proposition that we go back to 33. And maybe I'm wrong in that score. But before we do that, I think, and I would look to Mark and Tim, that we look at, say, okay, this is what 33.1 has come up with, and there could be modification of that if that's what we choose. Here's the proposed modifications of 33. And I know, Mark, you said initially that they were pretty minor, comparatively speaking. But the reality is we've gone long past those to where we are presently. And as we move forward to saying, what really is it that we're looking to recommend as the change of practice here in Ohio as it relates to 33, I would like to present that to the task force. And I don't know that you have that here because you're going to say it's what we suggested earlier. But what I think we could do is create, with your submission, a modified 33 and then address it at the next meeting, so that we're comparing apples to apples and have that discussion about, yes, we like that, no, we don't like that. Does that make sense? You like, all right. That way we at least make a decision to move on. So, which is what, that's why I get paid the chair bucks, right? Got it? Anyone else comment? We are in agreement with that process? Because now we can go on to something different. 295321 post-conviction relief petition. Brian, do we have the proposed recommendations that we can pull up on that, or Catherine, like we did before? Do we have I know we have them identified in terms of categories, but
I don't know if we have recommendations specific to 2953.21. I know I've pulled out some
and 35
things. I'm sorry.
And 35
and changes to 35.
Yeah.
I'm not aware of those. And I
what's the
apologize.
discussion that, okay, so let me do it this way then. In light of this discussion we just finished relative to whether we create 33.1, are there suggestions about the modifications for post-conviction relief petition, either the statute or the criminal rule?
Are you referring to post-conviction, the DNA testing?
No. Although if you want to comment on that, you can. Who said that?
I'm sorry, that was Mark.
Oh,
Hauser.
Mark. I couldn't see your mouth move.
Okay.
Well, Pierre was here. I know you were unavailable last month, and Pierre tried to talk about it, but he wasn't really certain what was meant by that. That ball is in your court presently, that if there's language to modify the DNA statute that you're proposing, we are awaiting and will welcome vetting that. Okay. But absent that, if there's something beyond that relative to post-conviction petition statute modification that you're looking at, that's what this part is about presently. Or anyone else? Joanna?
I think one thing we should address is the access to evidence. And to file a post-conviction petition, you have to have evidence outside of the record, but absent capital cases, you have no right to discovery and are frequently denied access to public records, especially if you represent the defendant, which you always do. And so I think working something into the statute that gives you access to evidence in post-conviction, access to discovery is necessary.
Do you have a particular suggestion in terms of a subsection of 5321?
I don't have it in front of me, but I could draft something up.
Okay. Other suggestions in terms of modifications, corrections, additions, deletions, both as it relates to the statute for post-conviction as well as the criminal rule 35, which is, as you all know, is far more direct and simpler. I did think we had some specific recommendations.
Judge Muda, I think all that we have is the previous brainstorming submissions. We didn't get any specific edits.
No, yeah, I understand that. I'm looking for those brainstorming suggestions.
Okay, yeah.
Okay, that I have, and I can,
that's what I'm looking for.
I can pull up the modifications of statutes and rules brainstorming document.
That pertain to the post-conviction.
I'm not on my work computer because it doesn't have a camera, so I can't pull it up. So if you can get it.
I have that. You want me to go ahead and share that, Judge?
Please. And this is just the document that we've created previously that to help refresh our collective recollections. Right there. So there's 3 bullet points, all dealing with.
And if you scroll down, I think it expands more. This is like the summary list, and then there's an expanded version if you go down.
Oh, there you go. Thank you, Catherine.
So I think 17, 18, and 19 is what we need to look at.
All right, Representative Leland, the number 17 happens to be presented by you. Do you wish to expound on this, talk about at least number 17?
Thank you, Judge. I mean, I'm just basically, it's been a while since this was created. I'm basically just reaffirming the position I think that was taken in the beginning about not having a time limit on the fact that people can bring these claims. I'm also, I mean, for my purposes, I am the least experienced of all the people on this group, and so I'm just throwing things out to talk about things. And I think it was interesting to me to have the potential of having an independent board review these kind of cases, but I don't know how practical in the long term that would be.
So as it relates to that concept, we will be addressing that, but we won't be addressing that until we get through the kind of the structural changes, and then once we make whatever decisions we're going to make as it relates to those structural changes, the big decision is the extent to which, if there will be a recommendation in what format the whole process of reviewing wrongful convictions should be considered in Ohio. I mean, should we essentially allow the present process, which is the patchwork of individual prosecutors' offices handling those petitions or claims as they arise within their respective counties. And whether or not they create CIUs or coordinate CIUs amongst various county prosecutors' offices. One, the second, of course, is the independent commission process. North Carolina happens to be currently at least the only state, although I believe there's another state that's in the process of creating an innocence commission. And the third process that is being employed is some states' attorney generals are creating a statewide CIU, so that you have not a patchwork of CIUs within a state, but rather the uniformity that would follow the state attorney general's office doing that. So those are kind of the three structural methods by which whatever we recommend should be the practice or process for vetting of wrongful convictions. We'll get to that. And in that stead, I'll let you know that we have reached out, and I intend to have representatives of the commission down in North Carolina present, so that we all become aware of how that process works, and be able to vet, its benefits, its shortcomings, and that sort of thing. But that won't be for 2 meetings from now, hopefully, if we get everything done that we're supposed to. All right. Tim Young, established standalone actual innocence claim other than 33.1, right, Tim?
Yeah. Sometimes we change our opinions after we talk it through with people who
What's interesting about that, though, Mr. Young, is there actually is a state, I believe it's Maryland, that does have on its books an innocent petition statute. And I think Representative Leland, I think you had referenced that with us once before. I might be wrong on that, but so there is a state. We do, it's in our materials. I don't know if you've looked at it recently, Tim, to see whether or not there's some viability for that here in Ohio, or if we're comfortable with the existing post-conviction process. If we don't, and maybe your other sub points get to the beefing up the current post-conviction process.
Well, I think specifically the two biggest areas of post-conviction that are problematic in terms of it being effective are discovery and access to counsel.
Access to
counsel,
yes.
The right to counsel. We have right to counsel on the death penalty side. I am not suggesting that there should just be the broad-based, every post-conviction should have a right to counsel, but we need to find a way where there is some arguable merit to these to make sure that they get counsel.
And to do that,
at that point, we're losing cases or seeing cases later that we see they filed post-conviction pro se, that were just horrible, that we then see in innocence projects or our wrongful conviction project, that had they had somebody then, might well have been able to much more quickly effectuate a better outcome or release on an innocence claim. So those are the two big broad issues. And as Joanna already brought up, the discovery side is very difficult as well. That if you can't get to it, you can't.
Well, are there specific recommendations that you believe would properly address that concern?
I don't have the language in front of me, Judge. I think the discovery one is really difficult to write, because at what point do you give discovery? Both of them are kind of on the same standard, which is at what level do you now open those doors to say you have the right to discovery? Is it in every case? And at what point should we assign counsel and provide compensation to that counsel? Because we're going to have to pay. These are appointed lawyers. That this is not going to be taken up solely by pro bono lawyers. So at some point, you're going to have to put this in a compensation schedule. What's the standard? What's that threshold? And that's the piece I think that this group needs to discuss. I can work on an idea more, and I apologize, I don't have a suggestion, but some standard to get to that threshold where we say, yes, you now get a lawyer, and yes, you now have a right to discovery in these matters.
All right. Any other comment on that particular point in terms of specific language relative to the clarification of the standard for opening of discovery?
I don't have an answer. I have more of a question for Tim, I guess, particularly with sort of appointment of counsel and discovery. I mean, how far down the road do you usually have to travel before you decide, okay, this looks like this has merit, and therefore getting some discovery would be beneficial? I mean, the problem is, you know, I mean, if it takes you a significant period of time, well, I mean, do we pay the attorney for the time in terms of essentially evaluating the case, evaluating the merits, talking to witnesses, I don't know, evaluating the DNA evidence if that's the case, before it then would be appropriate for counsel, because now you've made the determination that you think there's some merit? Or does it make sense even in the investigation phase? And I can tell, I mean, gosh, I mean, if someone came to me and said, look, I think this guy is innocent, and we have a conversation, you know, I'm going to want more before I say, okay, you know, go forth and investigate.
Judge, and therein lies the problem, the cart horse problem. They need a lawyer to get the investigation done. They need the investigation done to prove they need a lawyer. And therein lies the fundamental problem in all of these, at least from this point of view in the process. I don't have a wonderful answer for you. I think you very eloquently laid out the problem, though.
Okay, so while that problem has been laid out, is there consensus that the process needs to somehow allow for more open discovery in the appropriate, whatever that means, cases of wrongful conviction? And therefore, so that is the problem that we're hoping that we can come up with a solution to resolve.
Yeah, Gene,
yep.
Yeah, Gene, I think that there does need to be some mechanism for discovery. I think that, I mean, my understanding is the defenders and the OIP ends up spinning their wheels on these public records requests that, you know, take a lot of time and end up in protracted procedural battles, when if you could just send a discovery request, you could get it. I think the question is, how do we calibrate that so that it's not just open discovery on everything that's going to engender a lot of resistance, but it's more specific. And I don't have brilliant insights on that right now, but I do think there needs to be some mechanism for discovery.
And then the question is whether or not, like, the proposed 33(1) language clearly referenced both criminal rules, but really civil rules. And I think it dealt in the civil rule reference, and the application of civil rules was to, I think, because there's more vibrancy and structures, as you all know, as it relates to our civil rules of practice vis-a-vis discovery than the criminal rules. And if you frame it, I mean, the post-conviction petition statute itself identifies it as a civil proceeding, civil practice. So not really, but it's quasi-civil. So is there any sense from a task force member that this is not an area that needs any modification or clarification to? That's what I want to make sure, because if there isn't, then it's just a matter of where can we find some improvement in the existing statute to make a recommendation, either in the statute itself or in the criminal rule 35. Anyone? Tim, you say you wanted to take some time to think about and maybe come up with specific language. So I think, all right. So
with your permission, Judge, yes.
Sure, as long as we have that, because what we're going to do then is at our next meeting, we will vet the specific recommendations. If there isn't any that's forthcoming, then we just have to move on. Okay. And while we recognize it as an impediment, we're not making a recommendation for any specific changes. So that could be our identification.
Judge?
Yes.
I kind of wanted to similar to Tim, take some time to get back on whether or not to remove the language about the substantive grounds for relief prior to holding a hearing.
Okay.
I just want to, I want to think about that a little bit.
Again, that's fine. I think we all need to think about that, but I am going to impose on each of us the notion that as we vet these particular issues that we think need some either clarification, modification, correction, however you want to characterize it, that the proposed language needs to be submitted to us for consideration. If some of you want to meet offline, as it were, in preparation for the next meeting, we can do that, so long as we're prepared to address specific proposals by our next meeting as it relates to that, okay? Because it's clear, at least with respect to this discovery issue, everyone has a consensus. It's something we need to address. It's just the manner of addressing it that we are thinking about, and no one is quite in a position to make a suggestion presently, which is fine. We'll just have to do that next time. Are there other areas then? Let's look at the, so moving forward then relative to other areas here, Tim, in terms of your list that's before us right now, which would be additional categories to consider in terms of changes.
I think the rest of the changes fall under one of those two broad categories in terms of diligence for new trial motions where are filed on Brady. That's a discovery issue.
That's
Those
correct.
issues.
So where do
I think the
we
rest of them fall under those two big areas, unless I defer always to our expert Joanna. I don't want to leave out any major area that she would suggest as well, but I think those are the two big ones that encompass the rest, and we'll get language suggestions to you well before the next meeting.
I think the right to counsel is a separate area. And where do we address that?
The right to counsel in the post-conviction area?
Yeah. Are you suggesting that we contemplate modifying this statute to conform to the capital cases?
No.
Okay.
Because in capital cases, all PC get a right to counsel.
Yeah.
And I think that's probably a bridge too far for all PCs to start with a right to counsel regardless. Trying to figure out, as Judge Bergeron was suggesting on discovery, what is that trigger? What is that threshold where we then say, yes, it now attaches? Because I think that we have to keep an eye on a number of things that back inside of this that would suggest we shouldn't assign counsel to every case right at the moment of filing or on request. You're actually saying on demand, basically, if you do that.
Right. And if it's filed pro se, can a pro se litigant, for example,
yes,
file the request?
That's what I'm suggesting. We need to figure out a mechanism, and I don't know what it is. Maybe the pro se litigant should be. I think the pro se litigant should be able to file the request, but what's the standard to be measured by to answer the question? I absolutely think they should be allowed to ask. The judge should be allowed to appoint. I think an attorney should be allowed to ask to come into the case. All of those different points should probably be allowed in the rule suggestion to appoint counsel, but what's the threshold standard? And that's the one I need to get some language to you on.
Okay, so we have three general categories then so far, right? That we're looking at in terms of coming up with some kind of language. So between discovery.
I have a question just real quick here.
Sure, Steve.
I mean, this question was probably answered before, and I may have been the one that actually asked the question. But Tim, how do most of the cases make their way to your office? How do you find out about these cases?
Well, I mean, they come to us in so many different ways. I don't think there's a standard way. One, we do intake at every prison. So when, as you might be aware, every person who's sentenced to prison comes into one of the intake prisons. We staff those prisons mostly to just answer basic questions, a lot of simple questions, help orient people on what their jail time credit is, how to make those simple requests. we try to talk to every single person who had a jury trial, to have an individual conversation with each of them, because that's where these issues obviously arise most of the time. We also let anybody know if they have a specific question about their case, even if it was a plea, they can sign up. So we get cases in through the prison side. We also have a huge intake piece just through mail. Prison mail comes in, family mail comes in. We get phone calls from family members as well who've been investigating these cases. So it comes to us from a number of different ways. The final one I think worth mentioning is referrals from other lawyers who tried the case, who were involved in the matter and can't continue. There's no compensation for PC, so they hand it off and write to us and say, I think you should look at this.
Okay, thank you. Are there other issues then that, Brian, can you scroll down a little bit more in 18, please? These all, I think, are subparts of what you've already raised, Tim. Because my goal here is to make sure general concepts are discussed now. If there's other language or other categories that we can discuss generally, that's fine. And then everyone
Judge,
can.
I think one area worth pointing out is that the suggestion that strong probability be reduced to reasonable probability is probably not encompassed within those. It's a different standard of review. So that language is a recommendation, just so everybody's aware.
Reasonable problem, yeah. So
but I don't think it's
language within.
I don't think that falls into what we've been talking about. I just wanted to point that one out. I think that's a separate standard, a reduced standard that we think is much more.
Well, and I'll piggyback on that. Ohio is the only state that has strong probability. Every other state has reasonable probability.
Right. Okay. That would be number 4 then. Thank you. Anything else then with respect to these proposals? Brian, if you want to go down some more, just finish scrolling through the. And Justice Donnelly, I mean, this is really one of the big themes that you've already raised.
Right. What procedures can we create that bring these claims of actual innocence, not the ones that OIP believes have merit or the state public defenders believe have merit, the claims of the prisoners? How do we have these come to the top so we can identify claims of actual innocence and give them the equivalent of what defendants on the front end have as speedy trial rights? I'm looking for speedy hearing rights and speedy ruling rights. Trial court judges shouldn't have to take a year after they fortunately grant a hearing on a motion for a new trial. Trial court judges should not have it, this unreasonable amount of time to rule on something, on a claim of actual innocence. And this is our opportunity to put into statute all the frustrations that you've been talking about. And we have to take it to come up with bold language that gets trial courts on the back end to focus on the merits of the claim of actual innocence rather.
I'm sorry.
Okay, go ahead. I'm sorry.
No, I didn't mean to interrupt. I thought you were finished, Justice. So this timing issue is interesting because it does dovetail into areas outside of just the post-conviction petition statute. There are rules of superintendent that could be impacted. For the non-judges in the group, there are current reporting requirements of every judge in every level of court in Ohio presently. And it has to do with keeping track of pending cases and the timeliness with which courts dispatch their respective work. Curiously enough, and I've checked this, there is no current mechanism of reporting on these post-conviction processes. So if somebody has been convicted, the direct appeal is, the timing of the direct appeal is the responsibility of the appellate court. And once the direct appeal is concluded, if a subsequent post-conviction motion of some sort, motion for a new trial, whatever it is, petition for post-conviction relief is filed, there is no requirement tracking the timeliness of it, other than what's set forth in the statute itself. But the court doesn't have to report to the Supreme Court how many of these petitions are pending, nor how long that particular court has to rule on the petition that's been submitted for its decision, which is why in the Sutton case, the trial court took a year from its filing to ultimately render the ruling that got appealed. If there's an interest in imposing some reasonable time standards, or maybe not even imposing a time standard, but at least requiring the reporting of the time. I mean, that's more information than what we have presently. That would impact another area, not before our statute, which we can do. I just want other people to be aware if that's a sense of where we should, it's sort of like a starting off of where we should go as it relates to the timing and how long it takes for some of these petitions to be ultimately ruled upon or vetted by the trial court. We can do that. It's going to impact other areas.
I just want to acknowledge what the frustrations that advocates in this area have to deal with when dealing with untimely rulings. Their only choice is to file a writ against the trial court judge, the same judge that they want a favorable ruling from, and that's unreasonable. So we can, the only way you tell trial court judges that they have to do it is you put it into law, and you tell them this is what you have to do. So this is our opportunity to put some teeth into some legislation to say you have to do this. Otherwise, you'll be violating the law. And I think we need to take this opportunity to come up with language that requires judges to do that.
Judge, if I may,
John,
one thing that we may find too is that the first deadline for the trial judge may not be necessarily the deadline of you'll hold a dispositive hearing, but it will be make the decision as to whether or not to appoint counsel. And
Sure.
That may dovetail back to what we had just talked about, because it does us no good to have judges who, and I think what I'm saying is consistent with Justice Donnelly's point, because what Justice Donnelly is saying is we want a meaningful resolution of this case in a reasonable period of time, and dovetail that with Tim's point that if you want to have a meaningful resolution of a case, you may need to start by having an attorney. So those deadlines may go back to the appointment of counsel and not simply to the resolution of the case.
I'm aware of that, and you can build in parameters that would recognize that, right? With the decision points along the way. For example, is the decision of counsel, whatever the trial court makes that decision, is that a reviewable decision, final appealable order for purposes? So if the trial court hears a request for right of counsel, we modify the rule to impose on the trial court the obligation to conduct some level of scrutiny and review, perhaps a hearing, as it relates to the appointment of counsel. The decision rendered by that trial court, is that appealable? If the court says, you know what, you haven't met whatever the threshold is, whatever the standard that is articulated, and therefore I deny your request, is that appealable? I mean, that also is obviously impacted, and then each one along the way. It doesn't mean we don't do it. It's just, we're going to be mindful of it, the consequence of our actions, which is the only reason I'm pointing out the timing constraints relative to reporting of decisions. So, I mean, for example, you unless you do civil work, you may not know this, but the rules obligate every trial judge to render a decision as it relates to a civil motion within 6 months of the filing of that motion. I mean, that's just a standard rule that everyone knows and accepts, right? we don't have such clarity of or conciseness as it relates to these petitions, as articulated very well by Justice Donnelly. So,
Judge,
yep.
can I ask a question for Justice Donnelly?
Sure.
When you talk about, motions for new trial, and you're kind of sort of making it analogous to like the rights the defendant would have with like speedy trial. So if we want to impose these reasonable time standards, if they are violated, remedy for relief for the petition, if sort of like the reasonable time, his reasonable time is violated.
So you broke up. I didn't hear the
Just,
whole.
going in and out a little bit.
Yeah.
Oh, sorry. I was just saying, are you thinking that the petitioner could have grounds for relief in sort of the granting of the grounds for relief if his or her, sort of speedy trial or reasonable time since filing the petition and the rulings were violated?
Yeah, I mean, if we put these obligations into law, then, it's more of an incentive for judges to comply and not within a reasonable time, because they know if a writ is filed against them, it's going to be granted. Right now, when there's no, if you just say nebulous terms like reasonable, like one judge saying a year and a half to rule is reasonable. I don't. I'm sure the advocates, I'm sure the person who's innocent doesn't. So, I think we need to come up with incentives in statute standard in which requires trial court judges to hold a hearing, whether appointment of counsel is necessary, but then definitely on the merits, and then in statute requiring them to rule within a specific amount of time.
So I hope, does that answer your question, Meredith? So
yeah, I think it's like it's speedy trial in the inverse. It's
right.
Speedy trial. So
Well,
I get it.
except
So
I don't think Justice Donnelly suggested that. Should a trial court say hypothetically it's 6 months, you must render your decision on the merits relative to the petition, right? Within 6 months of it becoming decisional. Of course, we'll set aside what does that mean in and of itself, what is decisional. But assuming you get past that, your suggestion is if the trial court took 7 months, that somehow, regardless of the merits of the petition itself, the failure to render a decision within the time could be an additional basis to grant the petition. That's what I took your question to mean, right? Because that's what speedy trial you would just throw out. And I don't know that Justice Donnelly said that, but I think it's
yeah. I was just curious if it was on the table. I figured it was just brainstorming.
Yeah, right.
Yeah,
absolutely. That's why I would like to clarify it.
Yeah.
Yeah, we would. That's a great something worth considering. I mean, in order for statutes to have teeth, there has to be a penalty. But I just think, in my experience, judges are more likely to do things when it's in statute, because they know that writs are going to be granted when time constraints are put in there. But
exactly. Okay, so that's on the table now as well. Other thoughts as it relates to categories for modification of the post-conviction statute? Brian, you want to go down a little bit more? I think we're done with this section, but let me just look real quick. Yeah, the officer misconduct. We'll deal with that when we talk at our next meeting, when we talk about ethical.
Judge, if I may, I apologize. If I may, how many post-conviction filings are there in a year?
That's a great question, Carol. And because of what I said, that there is no independent reporting of them. So when a trial judge doesn't have to keep track,
Right.
keep track of all of his cases, it's never a pending case post-conviction. There's been some discussion that should be reported and required because of the amount of time. But like community control violations, probation violations, when a case comes back for the court's consideration, they're not separately tracked how many are pending. So you'd have to go, the only way you find out is going individually within the respective courts how many petitions you have pending.
And that's just state, that's not federal.
You know what?
And one of my sections I supervise is our criminal justice section, who handles the habeas for state and federal. So
Actually, I stand corrected. I think post-conviction, I think the statute does require to keep track of it.
because I know that Tim, maybe Mark, were talking about compensation for appointed counsel. You're going to have more of an impact if something, just consideration, you're going to have more of an impact on the Attorney General's office as well as the county prosecutor's offices with an influx of cases that require more work than maybe they've had in the past. And
Right.
that's another funding issue to think about.
Yes, and we will attend to that down the road. That doesn't really impact the statute necessarily.
No, but it goes along the same way though with what Mark and Tim were bringing up.
Yep, understood. So, Judge McIntosh, are you still on at the meeting?
I am.
Do you? I'm having a flashback. When you file your monthly report, do you have to keep track of how many pending post-conviction petitions are on your docket?
No. The only cases that I'm actually tracking would be those just that are pending. So I have no clue how many post-conviction cases I would have at any one particular time. Because I'm actually looking at, you mentioned that I just happen to have one here with me.
Yeah, okay.
Let me see, double check. Yeah.
Ryan, that's something we need to check. I for some reason, I thought there was some reporting requirements as it relates to post-conviction petitions.
Judge Zamuda, this is
Yes.
Sarah Andrews. I don't know about the court's reporting requirements, but in the commission's statutory authority and obligation, there's language that we will collect and maintain data that pertains to the cost of the counties of the felony sentence appeal provisions of 295308, and also post-conviction relief proceeding provisions in A2 of 295321. So maybe that's what you're thinking of, because I submitted that as one of the suggestions that we need a way to meet our statutory obligation, because right now we don't have it.
Okay. Yeah, that might be what I'm. So, but it's worth it. That is part of this transparency. That's really what it is, a more transparent process of what it's taking for a petition to be decisional for its ruling, and then the length of time it's taking for its ruling. So, Brian, I want you to make a note so we can.
Gene.
Yes.
If I can just backtrack a little bit. But no, I do get a monthly report of all my pending motions. So
but that's
all
your
my
internal
motions.
Yeah, but that's just your internal record, right?
Right.
Yeah, we're looking at the Supreme Court statistical reporting requirements.
No.
You know, so that we can look at on the dashboard of all the counties. Yeah, I didn't think that was the case. But we can, Brian, we can check with the case management section relative to those requirements, okay? Just make a note of doing that. We'll do that and be able to report back to this group thereafter, right? Any other considerations then as it relates to the post-conviction petition? I see the hour is 11:45. The next section we would be addressing is the ethical rules and professionalism standards. And we'll address that next month, along with that whatever specific language recommendations are submitted to us for proposal. I am going to ask that if you are submitting language for us to consider modifications of either 33.1 if one is, or the post-conviction relief petition, that you submit that to us. Let's talk about schedule, and then we can talk about time. So last month we had indicated that we were having our next meeting on April 16th. And you can see that we've changed that to April 23rd. The only reason I changed it to April 23rd is because that gives us, I think, a little more than a month's time to vet. It doesn't matter to me whether or not we do it on the 16th or the 23rd of April. What's the pleasure of the task force? The 16th?
Yes, please.
We have left. Yes? We'll keep it on the 16th. That's a little less than a month, but I'd rather do that. And that's because of the following information I will share with you. I have met with the chief. There has been some public inquiry about when we would be completing our task and our work, and submitting a final report to the chief for her consideration. And as you know, although this was established in February, we were long delayed as a consequence of the pandemic, and our desire initially, at least, to conduct these meetings in the quaint notion of being in person when we met and discussed these things. Quaint, given what has happened in the process. And we actually didn't start meeting, as you all know, until I think it was August. In any event, we're looking at completing our task and making a final report by the end of July, which doesn't give us a lot of work. I mean, a lot of time to complete the work, but I don't know that we necessarily need to. We just need to, concentrate and make our recommendations, vet them, and complete a report. So to that end, it is my hope that we can vet statutory recommendations next month, as well as address the ethical rules. Now, when you look at the ethical rules, you'll see that included in for the consideration is, and it's the chair's intent to review the Prosecutor Association's model rule recommendation that, as you know, they submitted in conjunction with their letter to the chief that they weren't going to actively participate in this task force. I do intend to invite Mr. Tobin, who gave us a letter relative to the model rule proposal, so he can present that to this group, whether he chooses to appear or not. We're going to vet that along with the other ideas. I wanted each of you to know that. That would be April. May then would be set aside for reviewing the 3 models as I've already described for you. In conjunction with that, we would have, as I said, somebody from the North Carolina Innocence Commission. I'm intending to invite, we presently have 3 CIU counties in operation in Ohio. Franklin County has a newly minted CIU. Summit County has a CIU department, and of course, Cuyahoga County has a CIU department. And I'm going to ask each of those 3 representatives to present in May, as well as it relates to their operations, so we can have a local sense of how CIU operates in Ohio. And then the 3rd category would be relative to state AG's office. And if I can find somebody that can present on that, I will. There are a number of states that are vetting that issue presently, and it's worth, and therefore worth consideration. I've not heard anything. Carol, you're still here, right? I have not heard anything from our AG, and I'm not suggesting you should or not. I don't know if that's something that has been vetted in light of what's happening or not?
Well, I can respond briefly. We can't get a conviction integrity unit because we don't have original jurisdiction to proceed on criminal cases.
Okay.
So we would be reviewing criminal cases from the
All
local.
you can do is recommend it to a CIU. All right, very good. Well, then we have that answer. So, and then that would then be May. June would then, our June meeting would be essentially wrapping up final recommendations, which would then give us a month for the report to be processed. So that's kind of the layout of how I propose we're going to proceed. And to that end, we have identified dates, April, May, and June, that you can put on your calendar. So our next meeting will be the 16th. John?
Judge, one thing I noticed is this, the Commission on the Rules of Practice and Procedure have their last meeting before they would be recommending rules changes to the court for publication in the fall on July 9th. And so it may be that you would want to reach out to Judge Huffman, who's the chairman of that commission, to see whether or not they would be in a position to accommodate us at the end of July with respect to an extra meeting that they could do or something like that, because we don't want to have a situation where we propose changes to Rule 33 and then we completely miss this cycle by virtue of when we get our report out versus when the Supreme Court puts out for publication their proposed changes to Rule 33, which when I was on the commission, the Supreme Court usually put out their list in right after Labor Day based on an August meeting.
I am aware of those time constraints, and the one step that I think is required between task force recommendation and vetting by the appropriate commission, rules commission in this instance, would be, I believe, that has to be submitted by the Supreme Court, if I'm not mistaken. In other words, our report is to the chief for the Supreme Court. And Justice Donnelly, you're here. Is that right? Is that the protocol? Whatever recommendations we come up with, if we choose to make certain recommendations to 33, your offices of the Supreme Court need to actually formally refer it for proper consideration, or are you not aware of that?
Yes, I believe we'd have to, well, we would first give it to the Rules Committee and then.
That's my point.
Yeah. But
it gets to the Rules Committee because of you.
Right.
So
I
actually
don't be a problem in that regard, but I agree with John's concerns there about not missing the cycle. So I'll do whatever is necessary on my end to make sure that happens.
Well, I mean, there's a couple of things we can do, but thanks for pointing out the timing issue. And next month we'll be telling in terms of the vetting of actual language, and once we agree upon potential language changes, how we vet that will then be the next discussion. Okay, John?
Yeah, I just wanted to throw out what the date was, and
yeah,
I know when, one of the things I will say is this on the Rules Commission, when I was there, when a task force came up with a recommendation, it was considered having been vetted to an extent where the Rules Commission felt fairly comfortable simply saying, we will take what you've proposed and forward it to the court, and then it can go out for that first round of public comment, because that first round of public comment is still one that is still fairly preliminary in the overall process.
Right. All right. Thank you. Anything else then? Other comments? Questions, concerns, issues y'all would like to raise before we adjourn for the day? Seeing none, thank you all for your time, participation. Have a great weekend, everybody. We'll see you next month. Bye now.